Hello, and welcome to this video explaining the remedies available for a discrimination claim and how to fill out a schedule of loss for a tribunal hearing. There are three potential remedies for a discrimination claim. For a claimant, that is, the employee bringing a claim, is successful in a discrimination claim, the Employment Tribunal may do some or all of the following. Firstly, they might make a recommendation aimed at reducing the adverse effects of discrimination on the claimant. Secondly, they might make a declaration as to the rights of the claimant and the respondent. The respondent is the employer or individual against who the claim has been brought. Finally, they might order financial compensation. This is uncapped. I will now discuss each of these in more detail. Firstly, the recommendation. The definition can be seen on the screen and originates from the Equality Act 2010, section 1243. It means that the court makes a recommendation for the respondent, usually the employer, to take specific actions to aid the position of the claimant. This recommendation is intended to be for the claimant's benefit. For example, the employer might provide an agreed reference for the claimant. The Employment Tribunal does not usually make financial recommendations, such as the claimant having their pay increased or to be awarded a new contract of employment. Financial losses arising from discrimination are instead dealt with by way of compensation. If the employer subsequently fails without reasonable excuse to comply with the recommendation, the Employment Tribunal may increase the amount of compensation paid to the claimant. Compensation will be explained later in this video. The second remedy available is a declaration, which comes from the Equality Act 2010, section 1242A. This means that if a declaration is the remedy granted, the Employment Tribunal will issue a statement that the claimant was discriminated against. Many claimants see some value in having a tribunal clearly state that what has happened to them amounted to discriminatory treatment. The third available remedy is compensation. Compensation is calculated based on the loss the claimant has suffered. There is no upper limit to the compensation that can be awarded. The objective of compensation as a remedy for discrimination is to award a sum of money that will put the claimant into a position that they would have been in had the wrong, i.e. the discrimination, not taken place. The Employment Tribunal will speculate as to what may happen in the future to calculate the correct amount of compensation. The discriminatory act must have caused the loss that is being calculated. The compensation covers two areas: financial loss and injury to feelings. We will first look into the recoverable financial losses. Some examples of what this area could include are loss of earnings, which could include any expected promotion or pay rise, loss of pension, loss of employment benefits that are able to be quantified financially based on net earnings, and expenses incurred, either as a direct result of the discriminatory act, for example, medical bills resulting from treatment for depression caused by the discriminatory act, or costs associated with seeking new employment, such as travel expenses. What financial losses you can include under this heading may depend on what the discriminatory act is that you are complaining of. For example, is it that you were passed over for a promotion and therefore think that you should be in a higher paid job with the respondent? Is it that you were sacked for a discriminatory reason and therefore are claiming for the salary that you were being paid in your old job? If you are, for example, making a claim that you were harassed by a colleague on the grounds of your gender, but still work in the same job as you did before, it may be that you do not claim any money under this heading, but you may include, for example, a claim for injury to feelings, which I will discuss later. The Employment Tribunal has the power to reduce compensation awarded for financial losses. These could include a discount due to the early receipt of a lump sum payment rather than receiving the funds over a long period of time, as would be the ordinary course of business if you were, for example, receiving a monthly salary. If you have attained new employment with equivalent or greater benefits, they will usually say you have ceased any ongoing financial losses. Any state benefits received will also be deducted. And finally, there will be a reduction if the claimant has not taken reasonable steps to mitigate their losses, which we will now discuss in more detail. A claimant has a duty to mitigate their losses, which involves taking reasonable steps to limit the loss, for example, by looking for another job, if the discriminatory act complained of was being sacked. The Employment Tribunal has discretion to reduce an award if they believe that the claimant's approach to mitigating their losses was unreasonable, for example, if it made no sense whatsoever. The claimant should provide evidence, if possible, of the steps taken, for example, evidence of any job applications made. The second area that financial compensation covers is injury to feelings. An important tribunal case outlines some guidelines for the level of compensation that should be awarded. The case is called Vento and Chief Constable of West Yorkshire, and the different categories of compensation are known as Vento bands. These might be referred to during your hearing. The lower band is for less serious, isolated, or one-off occurrences. The amount of compensation that can be awarded for cases within this band currently ranges between £900 and £9,100. The middle band is for cases that are serious but do not merit an award for the top band. The amount of compensation that can be awarded for cases within this band currently ranges between £9,100 and £27,500. The top band is awarded to the most serious cases, such as where there has been a lengthy campaign of discriminatory harassment or serious physical abuse. The amount of compensation that can be awarded for cases within this band currently ranges between £27,400 and £45,600. Consider the facts of your case and which band you realistically think your case will fall under. Please note that Vento bands change each year. The amounts shown on the slide are correct as of or on or after the 6th of April 2021. Any changes to these amounts can be found online. There are multiple factors that are considered by the tribunal in quantifying their injury to feelings compensation. Firstly, personal characteristics are considered. If the claimant reacted to the discrimination more severely than others, this should be accounted for regardless of whether the discrimination could be viewed objectively as less serious. Secondly, any medical condition that the claimant is suffering from, which was caused or exacerbated by the discriminatory act, will be considered. Thirdly, factors such as panic attacks, stress, loss of confidence, and interference with personal relationships will be taken into account. Fourthly, the nature of the claimant's job and the effect of the discrimination has had on their career will be taken into account. For example, is it likely that they will ever be able to work in their chosen industry again? Finally, the manner in which the respondent dealt with any grievance that was brought by the claimant will be taken into account. Did they investigate it properly or ignore it, for example? There are a few other heads of claim that can be included in the financial compensation sought for discrimination. These are reserved for very serious cases. As these are rare, the claimant's schedule of loss should usually focus on financial loss and injury to feelings that have been previously mentioned. The other potential heads of financial compensation are personal injury, if, for example, there is medical evidence of psychiatric injury, Secondly, a claim for aggravated damages can be brought, where the respondent acted in a high-handed, malicious, insulting, or oppressive manner, which aggravated the claimant's injury, for example, if they covered up or trivialized wrongdoing, or rewarded the perpetrator of the discrimination. Finally, a claim can be brought for exemplary damages if the compensation is not sufficient to punish the respondent, although this head of claim is extremely rare. In many cases, the claimant will bring more than one kind of claim. For example, they will complain that they have been both unfairly dismissed and that they have been discriminated against. If the respondent is found to be liable for both unfair dismissal and discrimination claims, be aware that the Employment Tribunal cannot award the same compensation twice. So, for example, if you have claimed for loss of salary as part of the remedy for discrimination, you will not then be awarded the same loss of salary as part of the remedy for your unfair dismissal claim, as this would result in double recovery. In the majority of cases, the Employment Tribunal will award compensation under the discrimination heading, as this generally will be more favourable to the claimant. For simplicity, the schedule of loss we will take you through in a moment is just going to refer to how to put together a schedule of loss where you are bringing a discrimination complaint only. We are also releasing a breakdown of the remedies available in unfair dismissal claims, with an example schedule of loss. Head over to our YouTube channel to view this. If you are drafting a schedule of loss where you want to include both unfair dismissal and discrimination heads of claim, and are unsure about the crossover and making sure that you do not seek double recovery, we would recommend that you seek advice on how to put together your schedule of loss, for example, from Citizens Advice. Their contact details will appear on the final slide of this presentation. We will now go through how to create a schedule of loss for a discrimination claim. At the top of the schedule of loss, write the employment tribunal that you will be attending, such as in the Leeds Employment Tribunal, and the case number. Also write your full name as the claimant and your employer or individual against whom the claims are being brought as the respondent. In this example, the claimant is Eleanor Dunlop and the respondent is Jerry's Plant Care Limited. The details section sets out the key information for the purposes of calculating the loss. You should make a list of your gross annual basic pay, gross weekly basic pay, net weekly basic pay, how much the respondent contributes to your pension annually, and the annual value of your employment benefits if you are claiming for these types of financial losses. For example, if the discriminatory act you are complaining of is that you are sacked. These will all be an amount in pounds and pence. If received, write the date that you started to begin receiving and stopped receiving job seekers allowance or income support. If you have mitigated your losses by finding a new job, write the date that the mitigation commenced and your net weekly pay in mitigation. For example, if you have obtained a new role that pays a lower amount. The second section is the financial loss section. This consists of calculations of the financial losses that have accumulated up until the hearing and the anticipated losses in the future. This example schedule of loss is drafted on the assumption that the discriminatory act complained of resulted in loss of the claimant's job with the employer, so will include claims for loss of salary, for example. Firstly, the loss to hearing would include the loss of basic salary. This is calculated by the number of weeks since the effective date of termination, i.e. the date that the employee was dismissed, multiplied by your net weekly basic pay. In this example, the claimant has been unemployed for 14 weeks and her net weekly pay, as seen in the details section, is £279.66. You will then write the loss of compensation and or any contractual bonus that you would have received within that time period. Then write the loss of pension benefit, calculating this by how many weeks you have been unemployed multiplied by the weekly pension contributions of your employer. Loss of other benefits includes any common types of benefits, for example, a company car and permanent health insurance. The value of these benefits is the cash value of these benefits to the claimant and how much it would cost the claimant to obtain them themselves, rather than the cost of them to the respondent. You might be able to do some online research to get a quote for how much it would cost you to pay to replace these benefits yourself. Expenses incurred includes any that are direct results of the discriminatory act, such as medical bills resulting from injuries from the discrimination, for example, for depression, costs associated with seeking new employment, such as travel, phone bills, and newspaper purchases to access information about jobs. It can also include the cost of additional training to obtain equivalent employment. And finally, it can include expenses incurred from setting up a business if the claimant has chosen to do this rather than seeking employment elsewhere. You will need to specify the details of the specific costs and an estimated total. Ensure that you have proof of all expenses to provide to the tribunal, if so required. Add the total of the amounts within this section and write a loss to hearing total. You will then be required to list the amounts that will need to be deducted from your total loss. This includes any job seekers allowance or income support received. You also must list any payments by the respondent. These include ex gratia payments, contractual payments such as redundancy payments, payments in lieu of notice, and contractual sick pay, and payments for permanent health insurance policies provided at the employer's expense. Finally, you must write any sums obtained through mitigation post-notice period. Then add all of these amounts up and write total less amount. Subtract the less amount from the loss to hearing amount to calculate the total loss to the hearing. To calculate the future loss of earnings, you must estimate the period of time that you will continue to be unemployed for. In this example, they estimate that they will be unemployed for 26 weeks, so times the number of weeks by the net weekly basic pay. To estimate the amount of weeks that you'll be unemployed, consider your skill level, the average amount of time for someone of your skill level to obtain new employment within your profession and the scope of location, and any personal factors, such as whether you are limited to travel for certain reasons. In this example, the claimant is unable to travel far as she cares for her elderly aunt in the evenings. In addition, you must write your loss of any commission or contractual bonus, including the period or date payable. You must also include your future loss of pension, including the period that this would be for. Write the future loss of any benefit as mentioned previously. Also include the future loss of other benefits, as discussed previously, and estimate the future expenses. Add all of these amounts up and write the total amount. You must then calculate the amount that would be received from future mitigation within this period. For the total future loss, subtract the future mitigation amount from the future loss total. For the non-financial loss section, you must first calculate injury to feelings and consider and explain which vento band that you think the discrimination claim would fall within. The claimant in this example has estimated that she will fall within the middle vento band. You will also be required to estimate the value of any aggravated damages, damages for personal injury, and exemplary damages, and explain the reasoning for these if you intend to claim them. Remember that these are rare, and you will, for example, need to include medical evidence to support these claims in the trial bundle. Finally, calculate the total loss by adding the financial and non-financial losses together. That is the end of this video on the remedies available for discrimination in employment claims. We hope that you found it useful. Help with the drafting of your schedule of loss is available from other sources, such as Citizens Advice.